So again, my name is Paul Kent. I've had the privilege of being special counsel for the town of Saratoga since 2012, which has been 6 years now we've been engaged in this process. And I think from the outset, the town board and residents such as yourself have been concerned about the potential impacts of a proposed dairy, and particularly the impacts with respect to groundwater and drinking water, among other things. The reason we wanted to have this meeting here tonight was to give you a little update in light of the recent Supreme Court decision, to let you know other things that are happening and other things that are going on, and to assure you that this is not over by a long shot. There are a lot of things that are still tools in the toolbox for the town that we can and will use to protect you and your groundwater and your drinking water. So before we get into some of the details about the court decision and some of these other methods, I want to just take you down memory lane for a little bit. And many of you may remember that the last time we had an informational meeting like this was, I think it was November of 2016. And at that time, we really focused on what the town had found out through its experts in monitoring with respect to groundwater issues and the potential for proposed impacts to the town's groundwater from the proposed dairy. And I'm here to tell you tonight that none of that has changed, okay? Those impacts are just as much of a concern today as they were when we last talked. But I just want to review a couple of those, just so everybody here recalls, what's at stake here. And at the heart of it, really it comes down to a pretty simple fact that when you have a town with soils that are as sandy as they are here in the town of Saratoga, placing manure and other nutrients on that soil will get into the groundwater. And some of you may have remembered from our last time we had a little demonstration where we had some of the local sand in a clear plastic container, and we poured colored water through it, and you could just see it going through that sand. That's what we're dealing with here. And really, the fact is no amount of precision nutrient application is going to change those facts. You have sandy soil, and when it rains, the stuff that's applied to that soil is going to get into your groundwater. And this isn't just an academic question. I mean, if this was happening out in an area that nobody lived, that would be one thing, but you all live here. And most of you have shallow wells, and you depend on that groundwater, which is very excellent water, by the way. Almost the entire town is compliant with nitrate standards, which is rare in agricultural or non-urban setting. And you're really fortunate. But the concern is that because you're using this groundwater for drinking water, where you have an exceedance of the groundwater standards, you've got a public health issue. Once you're above the state standard of 10 parts per million of nitrates, you are in an exceedance condition. So one of our primary concerns then is that applied manure across some 4,000 to 6,000 acres in the town is going to create some groundwater issues for you. Now, what's our basis for that? I mean, our little demonstration was fun, but that's really not much in the way of hard evidence. What do we have? Well, one of the things that we did back in November of 16 was we kind of went through a number of key indicators where we had hard and fast data. We have hard and fast data from the Central Sands Dairy, which has been the same owners and has been called the sister facility to what is going to be done here. So what better, and basically the same plain field sand soil, so what better indicator than to look at what's happening there? There have been wells that have been there both at the dairy and in the land spreading fields showing nitrate levels from 30 to 77 parts per million. In other words, almost 8 times the drinking water standard. That is not a small concern. That is hard data. That is what's happening to your neighbors just across the river. We have, somewhat fortuitously, a local monitoring well across from a field that was converted from forest to ag. That was kind of grandfathered in at the time. But we have both a before picture and an after picture. At the point it was forest, the nitrate level was 2 parts per million. Within 3 years of being converted to a farm field, it was over 12 parts per million. We also hired a groundwater expert who does groundwater modeling and takes the data, takes the information from a variety of sources, Stevens Point, our own groundwater monitoring network, and develop a model to say, okay, if we are spreading manure at the rates that they're proposing to do that, what is the impact going to be on the groundwater? And what we concluded is that for large portions of the town, groundwater would be above the 10 parts per million within as little as 3 to 7 years. So I think that's some pretty good information for us to be concerned about, what the impacts will be if this goes forward. And given those concerns, from the beginning, we were looking at a variety of ways to protect the town. I mean, I've been in the legal business now for some 35 years, and there's not a lot of certainty. And so the best way to protect yourself is to pursue as many possible options as possible. This is why lawyers sue everybody, because if you sue everybody, then maybe one of those defendants is going to work. It's the same kind of concept, I'm sorry to say. If you have enough different theories and ways to protect yourself, hopefully at least one of those will be available to do that. So what we have here today is we're confronting the fact that one of those avenues that we pursued, which was the zoning ordinance that effectively made the town unavailable for land splitting, the Supreme Court said that's not an avenue the town has. And I'll talk about the decision in just a second. But what I want to continue to emphasize is that is one of these avenues. There are a number of other things we're going to talk about tonight that are still available, and I think will still provide avenues to protect the town, their resources, and drinking water. So let me turn, if you will, to the bad news first, which is the Supreme Court decision. The Supreme Court decision was a split decision. There's 7 justices on the Supreme Court. The decision was 5-2 against us, which is a fairly common split these days on property rights kinds of issues. But the Supreme Court did some things that were helpful for us as well. So let me tell you a little bit about what the decision was about and what it did and didn't do. So the concept that was before the Supreme Court centered around the concept of what's called vested rights. And that simply is a legal doctrine that says if you were to get a complete building permit that complied with local ordinances to the town or city hall, at that point the town or city cannot change the zone. So even if the building permit hasn't been issued, if you have a complete application in, you are essentially grandfathered against any subsequent changes in zoning. This is the so-called building permit rule. If you have a building permit that complies with the law, you're good to go. So, in our particular case, building permit came in, but the town imposed a moratorium. went through a first round of litigation, and the courts held that the building permit that was submitted for Golden Sands for the 6 buildings on the dairy site was sufficiently compliant with the zoning in effect at the time it was filed, and otherwise was complete. And therefore, and that was filed, I think, in, if I remember correctly now, July of 12. We completed our zoning ordinance in November of 12, but that was after this went in. So the court said, complete application, the change of zoning in November is not effective. That was the first case. The second case, and the second case is the one that went to the Supreme Court, asked a slightly different question. And that question was this: even if the building permit was complete, does that building permit application apply to all of the land referenced with the applications when they were submitted to the town? And this had never come up before the Supreme Court before. There was no case law on this, and the Supreme Court acknowledged that. And I think many of you have a map that's a handout, and you'll notice on that map that you have like this little yellow square where the dairy is, and all the other green lands are lands in which the manure would be land applied from this dairy. Most of the time when you have a building, like it's a hotel, or it's a factory, or it's an apartment building, you have the building, and the building sits on the land, and of course, if you get the building permit, you can use the land for what you want. This was unique because the question was, does a building permit on 100 acres apply to 4,000 some acres that are literally scattered throughout the town? And quite frankly, it was a tough question. It was not decided in Wisconsin, and frankly, as we looked across the country, not a lot of cases have come up with this either. So it was a matter of what we would call first impression. And the court, again, the majority said, well, and I'm going to quote this, I think this is right out of the opinion. It says, the building permit rule extends to all land specifically identified in a building permit application. So that's what we lawyers would like to refer to as the holding of the case. But there were a couple of other things the court said in that process that I think are very important and will be important going forward. The first thing they said, and this was at paragraph 28 of the opinion, Golden Sands vested rights in the land expire when the building permit expires. In other words, their right to use this land is integrally tied to the building permit. They're building the building, and as long as they have a building permit, that's fine. If the building permit expires, their rights to build or to use the land expires. The second thing that they said is related, and it's also important. And here's what the court said. This was in a footnote. Our holding that Golden Sands possesses a vested right to use the property for agricultural purposes is grounded upon its building permit dispute with Saratoga. Close quote. In other words, the right to use the land is tied to the building. So if, for whatever reason, the owner chooses not to build the buildings, he can't sell this land to somebody else. He can't cut down the trees and use it to land apply stuff from Central Sands Dairy. It's tied to the building permit. So what he is grandfathered to do is to build the buildings that he described in that permit back in 2012, to use the land he identified in 2012, and that's it. So I think, that provides at least some context for what the Supreme Court did. Now, there are a couple of implications going forward, and this really gets into the topic of Okay, you said there were other avenues. What are the other avenues? I mean, we've gotten the bad news that they can use this land, it's not covered, it's grandfathered. What other options do we have? Okay, there's basically 4 of them. And the first one, and many of these points are also in the fact sheet that you have, but the first one is the town zoning ordinance remains valid and effective. The Supreme Court did not overturn the zoning ordinance, okay? The zoning ordinance is still there. All the Supreme Court said is, you're a grandfather. You slipped in under the wire, and so you can proceed so long as you use the building permit as you described it. Our zoning ordinance is still there, and that has some significant implications because there are things we can do still with that zoning ordinance to help protect the town. The first thing is that the effect of the decision as a grandfathered use, another term for that is a non-conforming use. Some of you may have seen this term non-conforming use before. It applies to any structure that pre-exists prior to the zoning ordinance going into effect. But there are limits, both under state law and under our own town ordinance, as to what non-conforming uses can do. You cannot expand them. You cannot materially alter or change them. And if you don't use them within a year, they expire. Okay? The dairy's calling. Sorry. But that's an important concept, that these are non-conforming uses at this point. Another important concept here is tied to the building permit itself, and that is this. As the Supreme Court said, Golden Sands' vested right is tied to the building permit. Okay? So, first of all, if the building permit expires, we're done. And they can't come back because the zoning ordinance would apply. Number 2, the use of the land is permitted as an accessory to the buildings. So if there are no buildings that go up, it's not like you can sell this land, as I said before, to somebody else to do this, or you cannot use it for some other purpose, like land spreading for central sands. And that means that unless those buildings are put up and actually used as originally projected, the land cannot be transferred. Now, I suppose if everything gets built, you could, and the operation is going full bore, you could transfer from one entity to the next. But what I'm talking about is kind of piecemealing it. If the buildings aren't built, the dairy's not operating, there is no ability to use that land for agricultural purposes contrary to the ordinance. So there are some significant things that are still tools for the town in that ordinance. Well, let's set that aside for a second. Let's move on to the second avenue, and that's the permit proceedings with respect to the Department of Natural Resources. Those have kind of been on the back burner since 2014. But we shouldn't forget that this is both an extensive process and a process for which the town is fully prepared to engage in. So what is that process? Well, and again, some of this is covered in your fact sheet. They're going to have to update their nutrient management plan, and the department is going to have to review the application and the information, and then there will be a public hearing on an environmental impact statement and on the permit for the dairy itself, the so-called CAFO permit. There'll be a public hearing, and we'll have the opportunity to present that. If the department then issues the permit, we have the opportunity to file what's called a contested case hearing. And essentially, that's simply a legal term that means we can challenge the permit in an administrative proceeding that's a lot like a court. We can put on expert witnesses. We can cross-examine their witnesses. There is a decision that's made on essentially a trial-like record. So that process is something that we would certainly avail ourselves of if the permits were granted. If you go through that process, there is an automatic right, well, assuming you exercise it, or what's called judicial review. And that allows particularly legal issues or other issues to be reviewed in circuit court. And then there is a right to the Court of Appeals. So when I say it's a lengthy process, we're talking a process that probably could be, if you run the full gamut, easily 3 or 4 years. The other part of this that I want to emphasize is, there's a lot of times where I get called from a town where the call is, DNR's just issued the CAFO permit. Well, actually they issued it 45 days ago. Can we challenge it? And there's a 60-day clock, and I've got 15 days to figure out, what I'm going to do to get stuff filed. I mean, we just did this last week for a town in southern Wisconsin, okay? So it happens. But when you go into a situation like that, it's kind of tough because it is an evidentiary hearing. You can't just pound on the table. You've got to have facts and witnesses and evidence. Folks, we've been preparing for this hearing since we were hired back in 2012. So if that day comes, we are going to be prepared. We have our experts, we have groundwater models, we have a monitoring network that now has almost 4 years of background data. There is probably no other place in the state where we have had enough lead time like this to develop a record for when that day comes, assuming it comes. So we are prepared. There's not a lot that we need to be doing other than just making sure that the monitoring network is kept up, but we're ready. And I want you to understand the town board has been incredibly supportive of keeping us in a state of readiness. So we have the DNR proceeding. What if that doesn't work? Well, there's another avenue here. One of the things we did in 2016 is we passed some town ordinances, specifically a livestock ordinance and a manure management ordinance. Those have been approved by DNR. They provide a requirement for any livestock operation to comply with groundwater standards, which, as I just said, we think they can do, and it gives the town the ability to enforce. Now, could that be subject to a legal challenge? Of course, I mean, this can be. But the fact is, we've got something on the books, and this is not zoning, okay? This is a separate ordinance, not subject to grandfathering. This is a separate kind of ordinance, like a licensing ordinance, that applies to any facility that comes in to do this. So we will have that tool available, and I'm sure that Golden Sands knows that we have that tool available. And it's something, quite frankly, we're going to talk about at the DNR hearing if we get to that. The final thing we have, and this is final avenue, and this is a little bit of, admittedly a course of last resort. But if nothing else works, we have, as I mentioned, an extensive groundwater monitoring network that now has 4 years of background data that we monitor quarterly. We have tested many of your wells. We have stream flow measurements and other things. We have, as I mentioned before, probably the most extensive history of background information for any of these facilities in the state. And what's more, because this is a situation where there isn't agricultural use today, it's forest. There is no existing other source of contamination. Many of you are probably following the situation in Kewanee and other parts of the state where, yeah, okay, there is contamination in the wells. Well, is it coming from this dairy? Is it coming from this dairy? Is it coming from someplace else? It's a karst formation. Who knows? Okay? and we make our best estimates, and we can do that. We don't have to do that here, folks, because right now your groundwater is great. If the groundwater becomes bad after land spreading starts, there's a pretty good cause and effect that can be established. And what's more is, notwithstanding the right to farm law, which puts limits on what you can do for nuisance actions against farms, right to farm law does not prevent us from filing an action where public health is involved. And that's what the case is here. So, again, I hope we never have to try that. But even the fact that that's available ought to remind people doing this that, you know, when I say this isn't over, it's not over by a long shot. I mean, we're talking a long time, and if that day ever comes that it gets built, the town still has remedies because we're prepared to deal with it. So, I guess in conclusion, what I wanted to say is, again, this is a long way from being over. We have options, both from zoning, the DNR proceeding, our own livestock ordinance, our groundwater monitoring network, that I am hoping will provide enough different avenues that one or more of them will be able to protect the town. So that's kind of a quick update on the decision and where we are, but I know that a number of you may have questions, and I'm not sure exactly what the protocol is going to be for questions, if I'm going to be the question person or if somebody else is going to help facilitate that. So in terms of, oh, there is a microphone. Where's the microphone? Oh, okay. So, good, thank you. We're coordinated here. We'll start with the question in back. Yes, sir.
You know when the permit expires?
The building permit?
Yes.
Well, the town has taken the position and sent a notice to Mr. Wysocki in, I believe it was November of 2016, that the building permit had expired. They disagree. We have not yet had an opportunity to determine who is going to be right in that interpretation. But certainly at the point that any building goes forward, that issue will be front and center. And it's something the town is monitoring, and we have the ability to raise the issue that the building permit has expired.
How can there be a question on that if there is a date of expiration?
Well, as it turns out, there was not a specific date of expiration on this permit the way it was issued because it came through the Court of Appeals process. So the date is a little less clear than it could be. But in our position is that it has expired because 2 years is the standard time for building permits to run their course.
The building modification, do they have to build all the buildings? Or if they leave one building out, is that a modification? What defines a modification on that building permit?
That's another excellent question. And cases on how much a non-conforming use can vary from the original design is a fact-specific case. It's not a nail-by-nail, board-by-board description. So there is a little bit of variation on what's allowed. Obviously, at the one end of the spectrum, they can't put up a granary. But if they build 4 of the 5 buildings and they're within the footprint and they don't build the 5th building or 6th building, is that a failure to complete the permit? Let's put it this way. If I was arguing on behalf of the town, I would say yes, it is. But to be perfectly honest, those are the things that lawyers can argue about. Yes, sir.
You mentioned the possibility of getting into the EIS process and concurrently the possibility of filing a contested case situation if the DNR's ruling on the EIS is not appropriate to the town of Saratoga. I understand that there is a strong possibility that due to changes in legislation recently, the EIS process might not be used by the DNR. Have you any information, inside information on the veracity of that statement?
So the question is it possible that the EIS requirement might be modified by the legislature? It has already been modified by the DNR from the time the application was filed until actually 2014. At that point, the DNR decided to go ahead with the EIS. Frankly, I think there is the possibility that the EIS part of this may become less important, but I'm not too worried about that, and here's why. The EIS process is designed to provide information and to solicit public input on a project where there's a state permit. And in many cases, it provides a broader presentation than you might otherwise have. And in some cases, where the hearing requirements are limited for the permits involved, it's really your only opportunity. Here, however, we have this CAFO permit that also requires a public hearing. So they're going to have a public hearing. Even if the EIS requirement were to disappear tomorrow, they're still going to have a public hearing on the CAFO permit. And frankly, at a public hearing, you can say whatever you'd like to say about the environmental impacts of that permit. What happens then is that's the public hearing part, there's then a decision, and if you don't like the decision, that's when you can file your contested case hearing. And there is where you can really get into the nuts and bolts of whether they're meeting applicable state standards. So there may be some changes, but I'm not too worried about those. Yes.
I believe when I received my letter back in 2012, there was, when I received my letter back in 2012, I believe there was a statement in there about the full circle farming and how they would approach deforesting our community and farming. And I want to say part of it was they would deforest it first, start to plant, and in the meantime, build the buildings. So that they could be operational when the cows came in because they need that for feed or whatever. And then land application for manure. Does this change that process? Do they have to actually build the buildings first before they can actually deforest and then plant?
Excellent question. And there's a couple of steps though. The first thing, before they chop down the trees, it has to come out of MFL. And all of that land right now, 90% of it is still in managed forest land. So that has to happen first. So the town will have some notice of that. That will be essentially their argument. They have to prepare the fields before the cows come home. I think that if we're going to have to decide based upon what we see happening. If that's what's happening, we're going to take that back to the town board. But one of the things that we have to evaluate is, okay, if this is the direction it's going, is it the time to raise the question of the building permits expired, or the non-conforming use is expired, or that there are some other provisions that we need to comply with. And I think that's a decision the town will make at the time. If there are these kinds of things that we can raise, should that happen. But that's going to be their argument, and this really doesn't change the sequencing that directly. I mean, if on the other hand, they were to say, we're just not building the buildings, but we are going to use the land, that, in my opinion, they can't do. But in terms of the sequencing, that's a more difficult question, and I think we would look at other ways to address that.
If they filed in July of 2012 and the building permit is only allowed for 2 years, that's July 2014. We are now up to almost July 2018. There's got to be something on record that says it's done. They've expired.
Well, as I said, we did issue a letter to them in the fall of 16 to that effect. I mean, keep in mind that this is complicated by the fact that the building permit was subject to litigation, circuit court, court of appeals. There was some time that went on. And the fact, and this is what's, it is a case of first impression. This is a bunch of farm buildings, and so the standard building permit doesn't fit as well. So, yes, enough time has gone by. We have provided that notice, but I'm sure that there will be some debate, and I don't want you to think that it's going to be as easy to say, well, it's been 4 years, time's up, because there's some complications here.
You mentioned that the town implemented a couple of ordinances that were separate from the zoning.
Yes.
And that would be hurdles for Mr. Wysocki should try to come here. We've got this beautiful data showing clear water. Can and should the town implement a nitrate ordinance that would set a ceiling that he could not meet should he come?
A good question. Essentially, that's what this ordinance does. It basically says you cannot exceed state groundwater standards. And it does set the ceiling, so that would be at 10 parts per million. So our position is that that ceiling is already set.
Should he come and he exceeds the nitrate level that the ordinance commands, what is the town's, well, how much power is in that ordinance to shut him down?
Well, the ordinance does give the town broad authority to deal with that. The extent to which that authority will be challenged is something that I can't predict at this point. But there is very broad authority in the town ordinance to allow the town to enforce that standard.
So we don't need a separate nitrate ordinance?
No, you don't need a separate ordinance because that's part of, the nitrates are part of those groundwater standards.
Thank you. If worst comes to worst, and I don't know if I will, but worst comes to worst, and Saki gets in here and pollutes our water, what is the feasibility of a class, because we have all this data that you already alluded to, what chance or what's the feasibility of us taking a class action lawsuit against Saki for destroying our groundwater? And along with, of course, our property values and everything else goes with it.
Well, as I said, again, this is one of these areas where the legislative deck is pretty well stacked to favor farming in the state of Wisconsin. And there is this law called right to farm, and the right to farm law significantly limits the ability of people to bring suits against agricultural operations. The exception, one of the exceptions, is where there is a public health impact. And that's why it's so important to have this data to deal with nitrates that exceed the drinking water standards, because in my opinion, that is a public health impact that could do that. Now, whether such an action was initiated by a group of residents or by the town or by both, those are things we would have to evaluate once we have the information in. But there is, I think, at least the ability to bring essentially a nuisance action should those groundwater standards be exceeded. There's a couple of guys in back that have been very patient, so.
Yeah, I'm one of your neighbors across the river. And this year, last statement you had here about the DNR permits, I was explained to by the Stevens Point water testing facilities there that the only time the DNR will actually step in is if your nitrate level reaches over 40. And that's because it's being consumed by cattle. It has no bearing on what the people are drinking. When Wasaki moved in, and they're a long ways from me, my nitrates went from a barely acceptable 10 with a brand new well to over 31 right now. So I would recommend everybody have their water tested at UW Stevens Point when they cost you $15. Get yourself a baseline, so if you do decide to have a class action suit later on down the road, you will have something to work with. And it's only $15 to have it tested for nitrates. Now, I was involved with the Juneau County testing that they were doing down there. And now I have a state representative coming in, and they're also going to test my wells and people in that area for pesticides. And that test is around $1,000, but they have agreed to pay for it because we've got such an issue down there. Mine went up over 20 points in 8 years on a new well. So I mean, this year statement you have here about the DNR policing it, they don't worry about it till it hits 40 and then only cattle are consuming it. That's what was told to me by Stevens Point.
Well, I appreciate the comment. Let me just try and clarify something for a minute. So two things. One is, in terms of the DNR, we are trying to use the information so that it becomes part of the permit process, and hopefully the permit's denied outright, or if it's not denied outright, it's conditioned in such a way to put enforceable limits in the permit, which then, which by the way is very rare, but if they are in the permit, then citizens can use that permit as a tool. You're right, DNR is not going to do anything unless it's over 40. But if we can build something into the permit that citizens have that right to do that, and I do think it's important, to have your water tested. That's great advice. And there is, again, this availability of citizens to do this on their own as a nuisance action, even if DNR chooses not to.
Yeah, just a couple of observations. The first one is that the state appellate court ruled against the Wysockies. The state Supreme Court did not have to hear that case, they chose to do it. We currently have a state legislature and government who are relaxing all of our environmental rules, approving expansion of CAFOs and high-capacity wells. Ronnie County is your best example. We have a state senator in Patrick Tessa who voted to support it. We voted in the office. We have a state representative, Scott Krug, who went right down to voting for it. He approved the Wysocki capital. So I feel strongly that very little is going to change unless action.
Well, you obviously, I'm not going to get in the middle of a political debate. I'd encourage all of you to get out and vote your conscience on these and other issues. But I will say that our approach here is not politically dependent. And because, quite frankly, we cannot rely on those things to help us here. But there are avenues, and I think that we have the ability through these other avenues in local courts and things to move this case forward.
Just one more thing. Is there any hope of having the Environmental Protection Agency get involved in the state this time? If we have one.
Maybe, but again, EPA regulation over CAFOs is somewhat limited, and particularly over the groundwater issues that are so much at issue here. And I could spend more time getting into it, so it's a maybe, but I wouldn't put a lot of chips on that to help us up here.
I got two questions for you. First one is, how many years' experience do you have litigating these types of The second question is,
what tools do you expect from Wysocki?
Well, so I've been practicing law since 1981. And I'm involved, a lot of my practice involves working.
Can't hear
with
you, can't
municipalities
hear you,
on-
please repeat the question.
on CAFO. Well, the question was, how many years' experience do I have doing this? And I was going to say too many, but so I do a lot of this for a variety of towns and counties. What tools does Wysocki have? I mean, frankly, he has the same tools that we have. It's just that he also, as being part of the Dairy Business Association, has a powerful lobby group working for him, and he probably, but otherwise, I mean, he has experts, he has lawyers, and he has lobbyists, just like we do. It's just they have a few more resources than the town does to pursue some of this. Yeah, well, there is that thing called money. Question way in the back.
Nope, this one first.
See, there's an advantage to standing at home. Sorry, go ahead.
My question is, for sale signs that we see up and down Highway 73,
Yeah.
was that land actually sold from Wysocki to another party? And if it was, doesn't it now fall underneath the ordinance? Zoning ordinance?
Great question. The issue, however.
Can we
see this?
Oh, I'm sorry. I thought you could hear because you have the mic. But basically, the question was, there's for sale signs up and down 73, and what happens to that land if it's sold to somebody other than one of the Wysocki companies? If it is sold for purposes unrelated to this dairy, then it is subject to our town zoning. I mean, that, and again, that's a powerful point. I mean, we think about, yeah, we lost this decision in the Supreme Court, but one of the things that the Supreme Court really, decision really says is your town zoning is valid. So if it's not this grandfathered use, you're subject to town zoning. So if this is for something other than the dairy, town zoning applies and it can't be used for agricultural purposes. Now, the real question will be, even if it's owned by somebody other than Wysocki, could it still be part of the dairy? Well, yes, a lot of times, the nutrient management plan part of the DNR, and that's why we have to see what that's going to look like when it's resubmitted, assuming it's resubmitted, that if you have a lease or some long-term interest in this land, there will at least be an argument on this side that it is still part of the dairy and the dairy operation and can be used, even if it's owned by some third party. Now, I think that there is room to debate that question, but that will be preserved.
Right here. So my comment is, we spoke about what the governor's going to do, what the EPA is going to do, and what the legislature is going to do. But what you guys are doing right here, having a town board that's hiring an attorney that's fighting this case for the last 2 years, is really important. And keeping your town board full of elected officials that are backing you on this is vital. And take that one step further and get your county board to get on board and read. Those are things you guys can do locally. You don't need to have the whole state change their mind, but keeping your tax dollars going towards this through your town is a great thing to do. And we fought the dairy over in Richfield dairy over in Adams County, and we spent $500,000. All the things you're talking about here is about that same cost again, but keep your town involved and keep fighting this. There's going to be a lot. We've been fighting Richfield Milk Source since 2011, and they're not there yet. And but we don't have the support of the town board like you guys have here. So I would just keep that in mind as you elect your local officials, both town and county-wise.
Mike, coming your way.
What happens to all the homeowners if their wells end up going dry at the shallow wells?
Okay, if if there is enough data to show that it's a result of a high-capacity wells, and there may be, I mean, part of our monitoring network, you know, we talk about nitrates, and yes, we're monitoring constituents, but we're also monitoring levels, and we have a very good view of that. That provides valuable information as well. If based upon the high-cap wells going in, we can see the groundwater table falling to the point where the cone of depression is getting down to affect private wells, then you have, you know, at least a legal action that can be taken, or the town does, against the owner for essentially a nuisance action to have your well replaced. There is also a statute that has some well replacement provisions in it. I'm not sure, I'd have to look at the facts to see whether any of that would apply, but basically it would be more of a private cause of action based upon what the data tells us.
In 87 and 88, we had to drive our wells at the corner of Bell Road and 73. We had to drive them down because of the dry year. We had to drive them down at least another 4 feet to get anywhere.
Yeah, and it will depend on, you know, a number of factors. But what I'm saying is by having a monitoring network in, we'll have data to give you, well, if in fact there's a cause and effect, and it's not just merely a drought year, but if there's something caused by their high-cap wells, we should have the data there that would help you in that circumstance.
It was after the Supreme Court hearing, they had made the comment that Waisaki's intending to work with the town of Saratoga.
Yeah.
So what does that mean? Would they be able to like build the buildings and maybe control the water? You know, is there a chance that they could be a good neighbor?
I guess I would say this. You know, in fairness, I think the town, as strongly as the board has been about all of this, it has not been in a situation to say, we don't want to hear what you have to say, or we're not going to talk. I mean, if he wants to come with a proposal, I, as an advocate, would say it's always valuable to hear what somebody has to say. The proposal may be totally unacceptable, but it depends upon what the proposal is. I mean, in my view, as I've expressed, I don't think there's a way you can have a dairy and nutrient spread all across the town and not have an impact on property. So if what wants to happen is a dairy and land spreading in some configuration, I think that's kind of a non-starter. On the other hand, if the proposal is, well, I'm not doing the dairy anymore, I'm going to be doing, I don't know, a golf course. Well, you know, I would entertain that. I think, you know, I can't say at this point, but I guess my point is that it's always, I always want to keep channels of communication open, and if he has something to say, great. But that's going to be viewed very carefully, and I think one of the things, because we've spent the time and understand the science and the data, that we'll be in a very good position to evaluate whether there's any legs to that kind of proposal or not.
I'm understanding this right. They cannot clear any more land until they build it. Because they've already done it over on Tower between 80th and 64th. And they've done it just a little south of that at Portage County. And they're putting manure on there. I've seen them many, many, many times in the rain. And I know it's gone right into that mountain.
Well, let me just try and clarify this a little bit. So first of all, in order to clear cut, they need to get this out of MFL. And they did that with respect to, I think, 160 acres on the east side of town. At that time, we told them, okay, you have it out of MFL, you can chop all of the trees down. And of course, the other thing, just as an aside, even if it is a managed forest law, they can still thin a great deal. And so it doesn't say you can't log or you can't do anything. You can't clear cut it and turn it into cropland, but MFL is a pretty flexible program. But let's get back to your case where they clear cut this area. It was pulled out of MFL so they could do that. We told them that you can take it out of MFL and you can clear cut it, but you cannot, if you grow a crop there, we're taking the position that you can't do that unless it is integral to the dairy operation. Now this gets back to the sequencing question we had before. Can they do some clear cutting in anticipation of building the building? Those are things we're going to have to evaluate on a case-by-case basis. And I think if, in fact, we see not just a few hundred acres, but thousands of acres that are being pulled out of MFL or clear cut, the town board is going to take a really close look at that, and we'll figure out what tools do we have out of this toolbox to help us with that. But I think we're going to need to see, kind of wait and see how far this is going to go before making any definitive decisions.
Will we be able to use the EPA results from the Armenia property in our defense and rejection of this CAFO?
Yeah, the question is, what about the Armenia results? Certainly. I think they're relevant. I'm going to I've used them here tonight. I'm going to use them in the public hearing. We're going to use them in the contested case hearing. I think they're close enough that they're relevant. Are they dispositive? Are they going to say, well, because of this, you can't do it? No. There is going to be evidence that is going to be submitted and evaluated, and certainly that's going to be part of it. But I just want people to understand that just because we have these gross exceedances across the river doesn't mean that we're going to be able to stop a permit here in Saratoga.
By the same company.
I'm just telling you the reality of it. As far as I know, that has not, I mean, like I said, we have better data here than any CAFO area in the state, as far as I know.
Yeah.
But it's no guarantee. But it's a whole lot better than we could be.
Yeah, one of the comments we heard earlier also was, can they be a good neighbor? And I would answer that it hasn't been shown that a CAFO can be a good neighbor. And I would warn us against getting fooled by things like manure digesters. And so someone will tell us that they're going to build this area and put it in a digester and you'll be okay. But digesters take out no, they don't take any nitrogen out. They take out methane, and you still have the same manure left over when you're done full of nitrogen. So if we're going to have that many cows here, there's going to be that amount of nitrogen that we have to deal with. And let's not be fooled by technologies that don't promise any real results.
Just in fairness on time, we kind of built this to go to roughly 7:30, so I think for the group here, there's a couple of additional wrap-up questions. We'll try and take those. I think there's also several websites. There's PetwoodCounty@gmail.com. There's some others on the material that you have. I will stick around for a while if you have questions yet. But I am still glad to take a couple of additional questions before we wrap things up.
I just need clarification on one of the things you said about bidding and these other lands and such like that. So when Wysocki purchased the land, he didn't purchase all that was originally in his nutrient management plan, and Red Creek Court purchased a large section of what Wysocki was originally going to purchase. Now, did I hear you correctly that Red Creek Court, even though they purchased the land after our zoning was in play, still could clear cut it and then lease it for agriculture?
Okay, and this is where we can get into a little bit more detail than we can here, but just to be clear. No, that's fine. I mean, this is part of one of the arguments that we made in the Supreme Court was, yeah, the building permit extends to all of the land that was described in the building permit application. Well, what land was described? Well, they submitted this map, okay? So I guess my position would be, at this point, if it was on one of the blue squares on the original map, it's arguably eligible to be included if it's part of the dairy. If it's part of something else, it's not. But they can't add land. In other words, if the red green orchard land was not one of the blue squares on the building permit application, in my opinion, it's pretty clear that that would not be grandfathered. So we'd have to kind of trace specifics on that, but there are some real limits there. How about one more question?
My well goes dry, are they gonna pay for it?
I can say, as I mentioned to the Southern gentleman, if the data supports that it's a result of their activities, at the very least, you would have a claim that you could file against them. Yes, unfortunately, that's true. Well, anyway, I want to thank you all for coming tonight. I really appreciate this. And